Item 1, Contempt 761 of 2025.
Your Lordship has been complied, Your Lordship.
Right.
You've already filed a compliance affidavit, Your Lordship.
Complaint alleges violation of. Complaint. This complaint alleges violation of the order dated 28/11/2025 entered in the complainant's WPC number 33969 of 2025. Person, after police notice, contemners have made appearance, have filed a copy of the office order number so 10849 HE dated 25/2/2026. A copy whereof avails at Annexure A to the compliance of the first of all, Government Council appearing for the complainant very clearly submits that there is substantial compliance of the order and that if there is any residue, liberty be reserved for his client to work out his grievance elsewhere in accordance with law. This is absolutely fair. Next in the circumstances, the contempt proceedings are dropped. Any delay is there?
No, Your Lordship.
No delay. They have done.
They have already.
Time, but 1 month or some.
That
is what Your Lordship referred that complaints letter dated. That is not the complaints.
Date will be different.
No, 10/3/2026.
10/3/2026.
That is the complaints report.
Annexure?
Annexure A, Your Lordship, to compliance affidavit.
This is 25.
Two complaints have been there filed, my lord.
Yeah.
The second one is to be taken into consideration.
An amount of 7,14,381 odd rupees have already been transferred to his account.
All right. Whether your client is happy?
Yes, ma'am.
Okay.
That the petitioner, this Union of India, should take instruction on the matter. In fact, I have found out 4 more judgments, and one by this Honorable Court, which is taken up by the Honorable Supreme Court on April 7, 2026. And the judgment I just received. That I have found out, Your Lordship. On that, I only place hot adjournment so that Learned DSJ will address on this issue, Your Lordship. Yes, oddly placed. You may kindly accommodate for the day. Then. Because I have taken out, that is in favor of the petitioner, but I only pray that Learned DSJ should address this issue because it's an issue that's to be decided. Because my lord has decided one issue that was taken over to the Honorable Supreme Court. Honorable Supreme Court has already decided on the issue. I'll serve the copy of the judgment to my learned senior, appearing for the opposite parties.
DG means Attorney General is coming.
No, and Deputy Solicitor General, my lord. DSJ, my lord.
Immediately after vacation.
Only, yes, Lordship. It's only a question of law. That will be said.
Sick time. Reluctantly adjourned at the request made on behalf of Learned DSG. First call immediately after vacation. Covered by the
32.
We can't fix the date because we are not sure whether we will continue.
The applicant, the petition are continuing more than 3 decades, my lord. He approached the London Tribunal for a regularization of the case. That is the, my lord. That is rejected.
It is rejected.
It is rejected, my lord. Even if the whole day. The larger bench decision, they have taken the view that it should be.
Page 34 of the brief.
Are you ready in the matter? Dispose of the matter.
You cannot do disposal.
Therefore, you accept it.
My submission is that earlier he has approved before this Honorable Court.
That was rejected.
So also before the Industrial Tribunal. That was also declined, madam.
Let us see. But how many years you have put in service? Totally, how many years?
30 years, my lord. Till now, I am continuing, my lord, under this department.
You want your client to jump into that Mahanadi river. Let us just take notice, then you file your. You cannot file because already did you file reply there?
It is government of India. Why not the BSNL is there?
Issue notice.
I am for the opposite part number 1.
Even if kept in advance, I have been selected and for taking into consideration of regularization.
Learned senior panel consent. Panel consent.
Yes, sir, I will.
Yes. On request accepts notice for the Indian government.
Open number 1.
Booking number 1. Emergent notice to the rest. Notice to 7 is dismissed. Why you worried the tribunal as a party?
I deleted. I don't know how to pray. I brought down that.
On the counsel appearing for the petitioner seeks leave of the court to Dixit OP number 7 tribunal from the cost title. Leave granted. Petitioner from the cost title. Next.
Item 3, WBC 11145 of 2026.
No, I am the guarantor. Mother. Son is the original borrower. My property was mortgaged with the bank. Bank proceeded, section 13 complete, auction, and auction purchaser I have also included as a party. My humble submission, this being a ST land, I am a scheduled tribe person. This could not have been equitably mortgaged with the bank because this is hit under section 22 of the OLR Act. 22 of the Odisha Land Reforms Act.
Did you reveal to the bank? I am a member of scheduled caste and now I want to market this property.
No, that ROR reflects my caste.
Did you tell them?
No.
Then that amounts to fraud. A law cannot be used as an instrument of fraud. Said Lord Halsbury long ago, more than a century ago.
My lord, my humble submission, the ROR of the land clearly reflects my caste. And I am a scheduled tribe. Admittedly, I am a scheduled tribe.
In your banking loan document, have you mentioned that you are a scheduled tribe person?
No, that instruction is not there, but everywhere it is said that.
None. We will dismiss the
My lord, item 3.
My lord, your lordship,
Item 3.
I can
I am having instruction to appear, my lord.
Hello.
Item 3, GD Corp.
petition seeks to lay a challenge to the coercive proceedings of recovery, which eventually have resulted into auctioning of the security property as provided under the provisions of Servicing Act 2000. Learned counsel for the petitioner vehemently argues that his client happens to be a member of scheduled tribe and therefore he enjoys protection under the provisions of
22 of the OLR Act.
under section 22 of Orissa Land Revenue
Land Reforms Act.
Land Reforms Act. Which year? Sorry,
1960.
1960. First of having heard learned counsel for the petitioner and having perused the petition papers, we decline indulgence in the matter in as much alternative remedy avails to him. Alternate and equally efficacious remedy avails to him under the provisions of section 17
Of the Surface
of
Act.
the Surface Act 2002. And there are no extraordinary circumstances for granting indulgence by this court. First, with the above observations, petition is disposed of, reserving liberty as sought. Reserve liberty to the petitioner to avail the alternate remedy with all contentions. Please need to send a copy of this order to copies by speed post immediately. Next.
Item 4, 5 have been adjourned. Item 6, WBC 11227 of 2026. Item 6. Item 6,
Yeah.
WBC 11227 of 2026.
Any urgency, bank matter? Also, let us see.
Item 7, WBC 11330 of 2026.
Come.
That's to say, this is purely a mercy petition. This man, he has taken loan, a house building loan. He has constructed the house. Thereafter, he suffered illness, heart problem. And his wife also suffered, she's bedridden. So only he prays Lordship 6 months time. Thereafter, he will pay the installment in this precarious condition. Nothing more than that, Lordship, because he has notice has been issued. He filed a writ petition before this honorable court. Then DRT he could not comply the order and make the payment. That's what precisely the point, Lordship.
But he has lost case before the DRT.
No, he has not lost case anywhere. DRT is pending, Lordship. DRT it is pending.
Will direct the DRT to dispose of the matter at the earliest.
Lordship.
Petition seeks reprieve for coercive proceedings of loan recovery,
Lordship.
loan having been availed for housing purpose. First, now that counsel for the petitioner in his usual fairness submits that if a direction is given to the DRT to dispose of SA number
38 of 2005.
Non-appeal dismissed, my lord.
Non-appeal dismissed by me.
I am for the opposite party bank, my lord.
SA is dismissed.
Not for my appeal. Lordship, I'll file.
Submits that the SA number so and so came to be dismissed by the order dated
12/2025.
18/12/2025. And therefore, this court should grant relief. First, next paragraph. Learned panel counsel appearing for the bank
On behalf of it, this was.
Yeah. Subject that the petitioner has got alternate remedy of appeal under section 18 of the Surface Act 2002, and therefore, there being no extraordinary circumstances, interference of this court is unwarranted. First, we agree. Next, in the above circumstances, petition is disposed of, reserving liberty to the petitioner to avail the remedy of statutory appeal as indicated above, keeping open all contentions of the parties.
Item 8, WPC 1240/2026.
Here it is a case, my lord, where the petitioner is
Suppose they give that money, still you will oppose the proceeding. It is open to the petition. It is open to the DRAT to consider contention of the petitioner as for discharging the loan amount if a reasonable period is granted in accordance.
Only house will, only house.
No, we have said that it is open to consider the contention. Okay.
item 8, my lord. May I please ask? Here, my lord, petitioner is the highest bidder, and his sale was confirmed on page 38, annexure 4.
When
It is annexure 4 on day 18 to 2026. Accordingly, I deposited it 25%.
possession is not given to you.
No,
Certificate is also given.
there is a problem. You know, the annexure 6 is your lordship's order in respect of the self-same borrower in respect of another property at Bhubaneswar. This is the stay order passed where undertaking was given by the borrower to pay the entire consideration amount in respect of another property at Bhubaneswar. And it was held in 2 days prior to this auction. And my auction was upheld in annexure 4, kindly see. Thereafter, no document was given to me, nor they provided the loan as per the undertaking.
Issue emergent notice, returnable within 2 weeks. All right.
Your lordship fix a returnable date.
No, we cannot at a stage. Judges are not supposed to fix the date.
My difficulty.
Start doubting the
Kindly see the my bread garment, my lord. I am going to lose entire amount. 87 lakhs I have paid, and there is no fault of mine, my lord. They are misinterpreting your lordship's order at annexure 6. What is my mistake, my lord?
the pendency, the denial of interim non-consideration of application for interim or relief at this stage would not prejudice case of the petitioner. Okay.
My interest and other thing, my rights may be protected, Your Lordship.
Item 9, WBC 12431 of 2026.
May I please, Your Lordship, the petitioner here before is with a innocuous prayer for consideration of the OTS proposal made to the OP number 4.
Will you consider?
He has been giving for last 14 months, no amount, no timeline. The 4 OTS proposal given date wise, I have the details. Against the 70 lakhs of due, first he started with 39 lakhs, then 41 lakhs, but no time limit, nothing. Now we want money, we don't want the property, Your Lordship. I bow down to Lordship. It can be directed to deposit 30-40%, then OTS proposal.
You deposit 25% of the amount with a precondition for consideration of OTS.
No.
OTS application cannot be put shooted like a school rocket.
Madam.
All right. Petitioner has joined his prayer as at the next one. Learned senior panel counsel appearing for the OP Bank resist the petition, contending that the petitioner is not a bona fide borrower, in as much as several such opportunities given for availing OTS proposal have not been properly utilized by the customer. Having so contended, now he submits that if the reasonable amount accompanies the OTS proposal, there would be no difficulty for his client to look into the same in accordance with best and RBI guidelines. First, next paragraph. In the above circumstances, this petition is disposed of, reserving liberty to the petitioner to offer the OTS within a period of 1 week, accompanied by a bank draft or RTGS transfer of 25% of the outstanding amount as a precondition there. First, if that is done, the bank shall take appropriate decision on the said proposal, keeping in view the extent RBI guidelines. First, all contentions of the parties are kept over. Okay, of course.
And my vacant number may be taken up to
Sure.
oblige.
Item 10, WBC 14139 of 2026.
Item 10, my lord, after vacation.
After vacation. That's the request of.
Item 11, WBC 14784 of 2026.
The position.
Item 11, WBC 14784 of 2026.
Opposite bankers.
Your bank. What is their case?
This one minutes, we have already minutes gone for sale and it is clear minutes. And so it is amenable on section 17 minutes. You can approach it like him.
Sale notice you have issued.
Already issued and it is clear minutes. It was 62 minutes.
Auction, nobody came. Sale notice is dated.
Dated minutes 26/3/26 minutes.
Again,
We have to go for
fresh notice.
yes.
Huh? The petitioner, being the borrower, is knocking writ jurisdiction of this court, knocking at the doors of writ court for assailing the sale notice dated
26/3/26.
26/3/2026. Under the provisions of 2012. Learned panel counsel appearing for the bank, OP Bank, submits that the auction that was sought to be held pursuant to said office having failed, the substratum for maintaining the petition has withered away, and therefore petition should be disposed of as having become infructuous. First term, we agree. WP is disposed of, ordered accordingly, and WP is disposed of. Okay.
Item 12, WBC 16025 of 2026.
Please, The petitioner has a very limited right to consider the representation annexure 3 has been given to the offering of one bank for consideration. But the fact of the matter is that the petitioner availed the rupees cascaded loan of 2 crores and mortgaged 3 number of properties. They have already sold the 2 properties and 1.91 crores have already realized. The rest not
Make use of the mic.
Lord, the petitioner has mortgaged 3 number of landed properties would get the avail the particular cash credit loan, my lord. And out of those 3 landed property, 2 properties were already, my lord, sold up by the bank on through auction, and my lord, the 1 crore 91 lakhs have already been realized by the bank. Under section 13.
How much money is remaining now?
My lord, under section 13 to notice, there was 2 crore 31 lakhs was the outstanding, my lord. So my now I have given a representation to accept 60 lakhs more, my lord, because meanwhile, my lord, they have also added the penal interest over and above the interest amount, my lord. So I have made a request to the bank that instead of selling that property, my lord, I have given you an offer to accept it as 60 lakhs, my lord. The outstanding is 40 lakhs and more 20 lakhs, my lord. So that annexure is pending.
Satisfied. Now remaining amount is more than
Lord, under section 2 crore 31 was under 13 to notice.
correct.
And
32 was issued
in 2014, my lord. So therefore, my lord, I have just given an
business loans.
on the business. And out of that, my lord, I have already they have recovered 1 crore 91 lakhs. So
Now outstanding amount is how much?
Lord, they have Lord, I have just given an OTS offer that I am
answering court's question. Court is asking,
my lord.
what is the amount now outstanding?
Currently, my lord, they have not given us. That is not.
No, you should have gone to the bank, sit across the table, and sought for information, then file the petition. You can't file a petition for requiring information, which otherwise you could have.
Lord, pass it over, my lord.
Bring who is your friend who appears for bank? Bring him also. Let us see.
Item 13, WBC 16035 of 2026.
Please,
Yes, Mr. Kerr.
Your Lordship, may kindly turn to annexure 24 at page 155. The relevant portion is 160, where your Lordship has extensively quoted. May I just place it so that your Lordship, for the benefit of my benefit, my lord, at page 160 minutes. The
160.
160, the relevant portion. The essential grievance of the petitioner, a registered micro, small and medium enterprise, is as to the coercive proceedings of loan recovery. Grievance is against the opposite party bank. At the stage of preliminary hearing in WPC number so and so, this is the first writ petition filed by the same petitioner. We had granted reprieve by the order dated.
But this was by myself and K.R. Muhammad Rafi.
No, this is in this particular petitioner. So here, because this is a third writ petition I'm filing now. So may I just give a bit of preface? This is a third writ petition. Your Lordship has specifically said, the Lord, that you go and sit with the bank. And your Lordship has also said that there should be a parley between the bank. And unfortunately, my lord, this parley word is somehow misconstrued. With great respect to my learned friend, this is the earlier writ petition. Heard so and so. The petitioner has made a challenge to the courts of proceeding constituted under the SURFACI Act 2002. A case has been made out for issuance of emergent notice and grant of reprieve on bona fide being exhibited by the petitioner for offering to credit 30% of the total amount of so and so on or before 30th of March 2026, for noon. Denying reprieve at this stage may cause enormous hardship to the petitioner, which is already mentioned as an MSME entity, which enjoys certain protection and privilege statutorily acknowledged by the MSME Act, as has been voiced by a few high courts in the country. No prejudice will be caused to the lender, inasmuch as even if the scheduled action is deferred, the interest on the amount outstanding shall accrue due and go on accruing due. Issue emergent notice in the above circumstances, application IA number 5421 of 2026 having been favored, the auction scheduled to be held on 30/3/2026 stands deferred, signed as, Lordship may kindly mark note, subject to the petitioner crediting 30% of the outstanding amount as specified above. IA is disposed of. Notwithstanding that, my lord, I paid that 30%. Then they came up with the second auction notice without Lord considering my case. That is the present the case which I am reading, my lords. There, your lordship, after observing everything, my lords, your lordship have referred to the earlier case of Justice K.R. Mahapatra and your lordship. Your lordship may come to page 163, my lords.
Yeah.
Paragraph 6. In the above circumstances,
May 2025 order.
my lords, in the above circumstances, the petition is disposed of, granting substantially similar relief as has been indicated above, keeping all contentions of the parties. It is hardly needs to be stated that till parley takes place between the petitioner and the banker, all courts proceedings are kept under suspension and suspended animation. In the event the parley goes adverse to the interest of the petitioner, they would have a fresh cause of action. Pursuant thereto, my lords, I intimated the bank at page 164, my lords, on 27th of April 2026. That is 164. There at the penultimate unnumbered paragraph, lordship got it, my lords? Unnumbered penultimate paragraph, it is also submitted that in terms of the liberty granted by the Honorable Court, a detailed representation shall be submitted before your good office within a period of 3 days for your kind consideration. Your lordship may kindly mark the date Monday, 27th of April 2026, left hand at the top, lords. Then this was duly received to them by them on the 28th of April 2026, that's at page 165. Then, my lord, they shoot out a letter of the same day, 27/4/2026, at page 166. Your representation, your lordship, got 166.
Yes.
Subject is your representation dated 27/4/2026 on the High Court ordered in WPC 11408 of 2026. We are in receipt of a captioned representation. We have gone through the same and understood the purport thereof. We would like to remind you that in terms of the order dated 24/2026 of the Honorable High Court in WPC 11408 of 2026, you were required to parley with bank. However, you have made no effort to parley with bank. It is evident that you intend to use the word order of the dated 24/2026 to linger the matter, and you have no intention to repay the bank dues. In terms of the order dated 24/2026, you have 2 weeks to parley with the bank, out of which 1 week has already elapsed. Needless to say, if you do not parley with the bank within another 1 week, the bank will proceed with recovery coercive proceeding as per law. My lords, your lordship may kindly turn, my lords, to my representation. That is Annexure 27 series at page 168. I give them a detailed representation. The lordship kindly grant me a minute. A minute stand. No, that was it's quite human.
No. Put on the AC. Go to there. It says, when one enters, how does they started?
It's quite humid now.
Yeah, there's humidity. We also generate more humidity.
It's always a cooling effect to address your lordships without great respect.
Yeah.
Page 168. This is my representation dated 30/4/2026. I give a detailed representation, and if your lordship will kindly turn to page 178, paragraph 34. 178. This is a part of my representation, paragraph 34. The petitioner
for the request
may kindly constitute or place the matter before the competent committee contemplated under the applicable MSME revival and rehabilitation framework or RBI guidelines for stressed MSME account. The petitioner submits that the issue cannot be decided merely as a routine recovery matter because the Honorable Supreme Court and so has recognized the mandatory character of MSME revival framework and the requirement of meaningful consideration of stressed MSME accounts before coercive recovery is pursued. Therefore, the petitioner's case may kindly be examined by the appropriate committee competent authority in terms of the applicable MSME RBI guidelines. Then the lordship will turn over the page 36. The petitioner is ready and willing to cooperate fully with the bank and competent committee by submitting updated financial statements, projected cash flows proposed, repayment schedule, business revival plan, details of payments already made.
Can we hear this matter after court becomes silent? Bar becomes silent.
I'd only request the bar.
Otherwise, how we should conduct? This is not a protect market. Yes.
May I just again place the.
Yes.
For your lordship convenience, my lord, I'll again place, my lords.
Again read 36.
34, I'll place 34 at page 178. I'm sorry, my lords.
No,
The
we have
petitioner-
to say sorry to you because you are being disturbed.
The petitioner further requests that the bank may kindly constitute or place the matter before the competent committee contemplated under the applicable
In
MSME
terms of that pronate.
pronate manner. So, framework so and so, so and so. Therefore, the petitioner's case may kindly be examined by the appropriate committee, competent authority in terms of the applicable MSME RBI framework. Then, if a lordship would turn over the page at paragraph 36, the petitioner is ready and willing to cooperate fully with the bank and the competent committee by submitting updated financial statements, projected cash flows, proposed repayment schedule, business revival plan, details of payments already made, documents relating to CGT MSC's coverage, and all other materials required for proper adjudication of the matter. The petitioner therefore requests that no adverse or coercive decision be taken without granting such opportunity of hearing, without considering the matter through the proper MSME revival framework. Then paragraph 38. The petitioner humbly requests the bank to consider restructuring refacement of the loan account by taking into account the MSME status of the petitioner, the revival potential of the unit, the payment already made pursuant to the order of the Hon'Ble High Court and applicable RBI MSME framework, the ratio pronate and CGT MSME related materials. Then Lordship may turn to page 100.
Sir, your reply to 13.2 is there.
Sorry, Lord.
Reply to 13.2 notice. What is your reply to
It's
13.2?
not, that Lords, I have not annexed that reply.
But
because
Pronit speaks about your reply in 13.2 only.
Milords, your Lordship would appreciate this is a case where I have been recognized as an MSME right
Correct,
in the beginning.
But for restructuring, what you are mentioning in para 34 has to come immediately after the demand notice is made in 13.2.
Well, what has happened, Milord? I'm talking about the liberty.
Now, if you speak of Pronit has given a timeline for
True, my lords, but that is before the recovery begins. Here, my lords, I am coming to your lordship prior to recovery, after repeatedly failing in my attempts to move the court. Your lordship give me the liberty to have parleys with the bank. The bank, my lord, immediately says the parleys have been done, as if this particular RBI guideline is not binding on them. Then what? And unfortunately, my lord, they construe your lordship's stay order as if it is applicable to that particular auction sale notice, and as if they have a liberty to proceed further. So after that, my lords, after this order, your lordships have signed, I postponed that auction, my lords. A third auction, my lords, is noticed, in notwithstanding my particular reply, and your lordship may see their reply, my lords.
What is the amount due now?
Lord, amount due according to the ticket. Amount due, my lord, your lordship may kindly turn to 184. After paying that thing, Lord, amount due according to them is 71 lakhs 59,533.70. After the payment of 31 lakhs, because 1 crore, your lordship may kindly turn to page 184. For which this particular, my learned friend is speaking of many other accounts. So far as the present auction is noticed, because this is the auction notice which has been subsequently challenged in the third writ petition. Because of different dates they are postponing. Here, in case you are interested to redeem your property, please pay the outstanding amount of 71,59,533. This is after your lordships directed me to pay 31 lakhs, 30% out of 1 crore amount. So that comes to 71 lakhs 59. And then, Lord, now they have scheduled another auction. If your lordship would turn at page 185 to 26/5/2026. And so far as my representation is concerned, your lordship may kindly see the language, how they have dealt with it. Page 167. I filed a representation on the 30th, and 4/5/2026 comes the prompt reply at page 167. They still refer to my old representation, notwithstanding my representation or detailed representation. We refer to you.
This you have read now already.
Sorry, no?
You have read it. Every word you have read of that.
No, this is the second one. After 30th.
So even this, you have how they construe.
And right. And after 30th of April 2026, my lord, the least minimum I expect from them is they should call me for attestation or whatever is the proceeding which has to be followed for putting up my representation to the committee. Having not done that, my lords, they keep on rejecting as if parleys have been, as if parley means namaste, handshake, goodbye. That is not the meaning of your lordship. That was never the purport of your lordship's order. Parley, my lord, that you have to sit across, I am reading, my lords. You sit across the table, follow the RBI guidelines, refer me to the committee, and then you do it. Then, my lord, this is the third auction, my lord. First auction, your lordship has stated. Allowed me to pay 31 lakhs or more, 30%. I paid that amount. So that auction goes. Again, my lord, a second auction notice comes. I come to your lordships. Your lordship sent me that you please have parleys with the bank, which I, my lord, your lordship has also used the word that they have graciously agreed for a parley. That is the petitioner as well as the bank. After I go, my lord, after I file a representation, they reject it as if the parley is over. Now again, we are putting it for the third time, the same for the same amount.
Who should take the decision actually?
Actually, the bank, lord, if the bank, lord, I have filed my representation, lord, to the chief manager comes authorized. So can you deny that you have not received it? Your lordship may kindly see, lord, pursue. Pursue means what?
Only they have sent the letter and slept about the matter.
We have not never slept.
What they should after sending letter?
They have to take the effort. What is already bank stated?
Mr. Kar should go and do gymnastics. They have sent a letter to you.
Approach to the bank authorities.
What approaching? Is it not approaching in writing? He has sent a letter. You should have called him. You should have called him. Offered a cup of tea. He is not your slave.
Yes, madam.
He is a borrower, MSME. And you know the law relating to the status of MSME entities. You should have called him. You have sent this bare representation. That's not going to do. You have to do like this. They would have done. You are a bank.
Send the letter and to that slept about the matter.
What he should do?
That is why we have.
You have slept over the matter, not he. Your bank has slept over the matter. Bank should have called him.
Bank, we have already filed a review petition for modification of the order.
That's all right. But as long as review is not allowed.
Modification of the order. Earlier order, Justice Kehar Mahapatra order, that is of the Bank of Baroda, in which the Bank of Baroda has not complied.
No.
Bank of Baroda has already started the auction of that property.
Friendly.
That order.
He has shown bona fide.
Yes, ma'am.
By depositing 31 lakh rupees.
That is outstanding minor 1 crore 22 lakhs.
That's all right. 31 lakh will be about 20% of that.
Out of the auction price.
25%.
Outstanding is more.
That is not concerned the present
of
auction.
it and we'll hear it. Gradually we'll hear it. We'll stay everything.
3 bar you are purchased.
No, they are
22 lakhs, man.
You are only speaking about the outstanding.
The essay is pending, madam.
No. What about the order? What about the
order of the High Court? High Court, and you agree, we have recorded that you graciously agree. We have put some case elements in your submission. Those elements are not being reflected in your submission nowadays, today. Bank should have called. You have given this representation. You have already wasted 1 week. Where has he wasted 1 week? 24 is the order. 27 he has given the representation. Where is the wasting of 1 week? You tell your bank officer, this is not the way. Borrower is not a slave. When he kindly listen,
possession of the property.
Kindly
that
listen.
is in the custody of the bank. So how
don't
can
want to listen also.
Without this account, when the account will not be standard, how the bank will?
You will not listen to us also.
Yes, madam.
In Gujarat Finance Corporation versus Lotus Group of Hotels. Apex Court said, take out that judgment. Very good commentary by I.P. Massey in the administrative law. You see, your bank is an instrumentality of the state. Even when there is a loan contract, he will not shed, borrower will not shed all his fundamental rights at the gate of your bank. He retains them even when he avails the loan. He is statutory entity, an MSME. MSME has got special status. There are Bombay High Court judgment, Karnataka High Court judgment, there are a series of judgments. Borrower should repay is true. No dispute with regard to that proposition at all. But some process is there. There are 2-3 orders of this court. Under the shadow of that, you should sit across the table and talk to the person. You should have placed the papers at the hands of particular committee, which would take the decisions. That is the request he has made. You should have said, no, it will not go to committee. We are going to decide that.
That's committee cannot constitute.
Therefore, we never told you that.
Yes, ma'am.
We agree with you.
Yes.
But
That
you should have told him.
Constitute since 1 year. If let us admit a committee will constitute. How many days committee will constitute?
How do I know?
No specific date to constitute it.
Whether he will say or he will say.
No, madam. In the earlier order of the Bank of Orissa, no committee yet has not constituted. Bank
He refused and give a date to
So
sit
this is the order.
across the table. That's all. No committee.
They have sent the letter, madam.
You asked,
They have not to meet the bank authorities about 1 crore 22 lakhs.
No, out of 1 crore, 2 lakhs, 31 lakhs have already been paid. It is in the order.
In 90 lakhs is pending.
Right.
Taken the physical possession.
That is why.
very well, let it be with you.
Yes,
But where is the consideration?
And they are telling that restructure. How we can restructure?
You wanted to say no. You should have said no. But where is the date?
Reach to the bank authorities and approach to restructure whatever the amount they should pay and the account will be restructured.
No.
Nothing is done. What is
That
Heard Senior Advocate Mr. Kar and the learned panel counsel appearing for the OP Bank. This case is a checkered history. First off, this is the third time that the petitioner MSME is before this court. First off, a perusal of the petition papers makes out a specific case that the petitioner borrower, which is an MSME entity, did not have a fair treatment, which the bank, being an Article 12 entity, ought to have given. First off, petitioner has already deposited a sum of rupees 31 lakh in terms of the order dated.
But order dated 24/3/2026.
24/3/2026. That is not in dispute. First, argue the matter merits a deeper examination at the hands of this court post vacation. Now, only urgent matters being taken up. First, in the above circumstances, what is the interim order you have sought for, sir?
Now, the interim order for stay of the auction scheduled to be held on
The
26/5/2026.
Auction is hereby stayed until further orders. Call this matter in the second week of July 2024. Yes. Yes.
Item number 6.
Yes, Pranav.
Item number 6, WPC 11-227/2026.
Picture. Learned counsel for the petitioner has filed a memo in the open court seeking leave to making submission that matter having become infectious, we discord of accordingly. Ordered accordingly in WPC.
Item 14, Contempt 3079/2026.
Writ of appeal, state's writ appeal was dismissed. Confirming the order dated 16th of October 2023, you also directed them to comply the order of the learned single judge within a period of 2 months. Now, this has nothing has been done. That's why I filed the contempt.
Within 2 months over when?
In April 2026, order, ULSC's order passed on 2nd of February. What's from the date of communication, my lord? Yes, 24th.
What
Communication.
is being done?
Let's take instruction.
Don't think issue police notice. We speak through police sometimes because we are fed up with all the tendency going on because of contempt matters. Yes. Huh? Date to put on the 3rd July.
But we little bit-
Mr. Commissioner, what is your communication to this?
communication 24 to on that the research accepted back.
What is the call?
Have you communicated the
Yes,
order?
duly received on 24/2/2026.
Where is that?
Page 3.
That issue. What is? Yes.
Merit, a little bit matter on that date. 6 writ appeals you will receive dismissed. Similar, you will submit tag it up along with that.
How? This is contempt matter.
This is content matter. Similar notices. Your the lordship.
In all these cases.
All these cases. Same 1610 order of the honorable. Similar matters. You will receive dispose of.
No, let those matters come
Tomorrow, my lord.
tomorrow. We'll issue that tomorrow we mention, we'll tag this matter with this.
Yes.
Yes.
Deeply.
Yes.
Item 15, Date appeal 2427 of 2023.
My lord, this case was tagged to a batch of cases on the particular date. This is case of regulation. Other cases were for pension arising out of a voucher. No, my lord, only the recall my lord's order, because this has been disposed of along with those batch of cases in that Basanti Das case. Basanti Das case was for the work charge employee. We are not work charge, we are real employee. Rather, my case is covered by the judgment of this honorable bench. Kindly. That's 12/4. I have given a copy.
It could not have been disposed of
along
in
that
Basanti.
Yes, ma'am.
Basanti Das was not applicable.
Basanti is different. Work charge employee.
Yes.
What child employee?
Yes. It is the group, my lord, that is probably advantajely it has disposed. I have highlighted note of that.
It should be disposed of in terms of
My lord's judgment. This is the judgment my lord will deliver.
Barendra.
Barendra, yes. Barendra Krishna. This is covered by this.
This order was on 2nd of February.
Again, see, got a bench rest. I have mentioned also, but order was passed.
We'll recall this order, brother.
My lord, this petitioner's appointment was much after
The 12/4/93.
1993.
That has been dealt in Barendra Naik case.
Has been dealt with in
My lord.
In Barendra Naik case. That is the case.
We'll recall that order. Then we'll hear you. Then we'll pass the order. Because once it is recalled, then on the same day we cannot dispose of the matter
No.
without giving an opportunity to
Yes.
hear the matter. The appeal was followed up by the order dated 2/2/2026. Keeping in view writ appeal number 1598 of 2024 between State of Odisha
It did.
versus Basanti Das, disposed of on
My lord, that was on same day, 2/2/26. The same batch of case. This is the order.
1/2/2026.
It's a due.
Learned Counsel Mr. Das, appearing for the applicant, submits that the decision in Basanti Das is not applicable to the appealing question. And what is applicable is the case in writ appeal number 1445 of 2024 between State of Odisha versus Barendra Krishna Nayak, decided on 29/1/2026. First, a prima facie case is made out as to non-applicability of Basanti Das Supram. First, in the above circumstances, this application having been favored, the order dated so and so is recalled, and as a consequence, appeal is restored to the board for being heard afresh immediately after the decision. Order. Yep. But actually, right way is review, not the filing IA.
Because I have made a mention, my lord, that
That maybe is the procedure.
inadvertent mistake.
Apparent on the
Yes, ma'am, that-
61 Supreme Court,
That-
where a binding decision is ignored, It is an error apparent on the face of the record.
Not an error.
Under Order 47, Rules 192.
Yes, ma'am. That I
held to your
yes.
proceedings.
Not an error because in the group of cases, that is why I filed.
No, you are wrong. Yeah. Anyway,
Item 16, New Appeal 2623 of 2024.
In this case, my lords, the penalty, my lords, was on leave for 13 days, my lords. That is from 21/1/2014 to 10/2/2022. I was absent for my lord 13 days. Or during that period, my lords,
did we hear this matter for some time in ED?
my lords,
Not this matter.
during that period, my lords, another person was deputed, my lords, to work. I am a cadre secretary to work as the cadre secretary of that primary cooperative society. My lords. After I joined, my lords, after 13 days, the managing committee, my lords, that is MIC managing committee in charge, he did not allow me, my lords. I approached to the assistant registered cooperative society and an inquiry was conducted by the Annexure 3 and the inquiry was dropped, my lords. Everything was appeared and the inquiry, my lords, that inquiry was dropped. Again, my lords, after 15 days, my lords, another inquiry was conducted, my lords. Just challenged by lords, my lords, that when the same self proceedings, my lords, the inquiry was dropped. Again, the same self proceedings, another.
Dropped on what ground?
That dropped on, my lords, that is, my lords, that are page 42 of the brief, my lords, because there is no allegation, there is no unauthorized absence. He has to be on leave, and that is at page 42, my lords. The allegation of BA and MIC are to be dropped. The secretary prosecutor does should work in his own place, that is applicant, my lords. With the withdrawal of the cadre secretary to be assigned place of posting, the secretary, PM, and MIC should work unitedly, coherent, and coordinate manner without any infringement in interest of the members of the shareholders of the Hon'Ble SS. Steps should be taken for posting of peon along with review. That order was on 7/8/2014 at past months.
After one sentence, you have to stop. You have to assess whether you are speaking truth or not.
Yes.
Is it not?
Yes.
You have to doubt.
Then that, my lord, that the inquiry officer has submitted.
Reader, that is the report of the inquiry officer.
Yes, that is the inquiry officer report.
Where is it accepted?
That is, my lords, that is at the findings. Turn to the findings, but turn to the remarks, my lords. At page 40. 40. An employee with more than 20 years experience in an organization had leave on health ground and steps taken on his leave in a piecemeal is purely monopoly and personal without receiving any conference from higher quarters. The PM, MIC, and secretary should work unitedly for the better interest of the members and shareholders of Ambassador SCS, and after giving promotion to Sri BK Das as a member of a promotion committee, the BM and MIC have designated him as the secretary and sometimes the secretary in charge, which is contradictory as well as conflicting. The interpretation of the word absconded is an over-exercise of power and infringement of one's prestige and character. The same person's Tilochan Pati is communicated to higher quarters.
So proceedings or allegations are dropped. Come to 42 now.
42 months.
Read the title to 40, para 10.
Suggestions. The allegations.
This is the suggestion.
This is the suggestions.
How suggestion is acted upon by whom?
By the inquiry official.
This is only suggestion. A suggestion is not an order. Somebody should act upon it. Yes, we agree with the suggestion. We do not agree with the suggestion. Where is that decision?
That is, my lords, that is that part for the page, my lords, that is. That is. That is an observation at page 36.
Page 36?
Page 36.
What is this document?
That is the same inquiry report.
Somebody should act upon the report. This is sent to you. Is it not? It's in your favor, apparently. And what happened to this report suggestion? These are all versions of the inquiry officer.
Inquiry? Yes.
They are all inquiry officer's suggestions.
Yes.
Recommendations.
Yes.
Unless somebody, they do not have proprio vigor power, strength, efficacy. They can't operate on their own. Somebody should act upon them. Where is that?
That is, my lord, sir.
Who is the competent authority to take a decision on the
Authorities view.
The competent authority is the MIC, my lords.
whether that has taken the decision?
Is that MIC was a present in the inquiry, my lords. MIC was a present, and on his presence the inquiry was conducted, my lords. That is that.
If at all. So who is to take a call on that finally, after the inquiry report is submitted?
After inquiry report, my lord, he suggested to drop the proceeding.
After that, any order will not be there.
Any order dropping the proceeding?
No, then my lord said that they have not dropped the proceeding. Again, my lord, after 15 days, again, my lord, that is MIC who was MIC, again another charge, the charges, at annexure 5.
For the self-same
On the same
misconduct
charges.
or unauthorized absence.
On the same set charges, another proceeding was initiated once. I challenge, my lords, when the proceeding has been, when the inquiry was conducted in the same.
What the learned single judge said?
Learned single judge, my lords, that is, my lord, he has taken the note, my lord, that is at a paragraph number, page 60, my lords, para 6. The petitioner appeared before the inquiry officer, Sri Ranjit Kumar Sahu, Inspector Corporate Society, Jagatpur, who in turn, after considering all available records and hearing both the parties, have finally observed that allegations to be dropped. The secretary, the president, should work in his own place with withdrawal of cadre secretary, and further, the secretary, BM and MIC should work in tandem unitedly in a coordinate manner without any detriment to the interest of the members of the shareholders. And finally, my lord,
This is by whom?
this is
The observation
this is
which the learned single judge has made.
no, this is the pleadings of the petitioner. And observation, my lord, that at page 64.
Mr. G, what happened to the report of the inquiry, suggestion of the inquiry officer?
My lord, your lordship, may kindly have a look to the judgment passed by the learned single judge.
Yes.
At page 65, paragraph 9.
It's only about the payment of subsistential acts.
No, he was, despite multiple letters, the petitioner neither resumed his duties nor did hand over the responsibility to the junior supervisor, impeding the smooth functioning of the society. As a result, the opposite party number 3 placed the petitioner under suspension. According to order number so-and-so dated so-and-so from the
Suspension happened.
Yes.
Subsistence allowance is paid. Inquiry was held.
My lord,
Report
it is
has
clear.
been submitted. Second suggestion is again sent.
Yes.
What happened to them?
My lord, thereafter, it is his responsibility, my lord.
Whose
During petitioner's responsibility.
How he is responsible?
My lord, during paddy procurement, he is to be present there.
No, question is not that.
My lord,
No,
in the absence.
there is a misconduct.
Yes,
Is it not?
yes,
That has been inquired into.
yes.
And inquiry report is submitted. To whom it is submitted?
It is submitted to the inquiring officer.
Inquiry officer will submit his report.
No, sorry, sir. The appointing authority, to the appointing authority.
Appointing authority or disciplinary authority.
Disciplinary authority.
Whichever.
Yes.
What the disciplinary authority has done on the consent report. Why again one more inquiry? You are entitled to hold. If you say we do not agree with this inquiry report, number one, why you are entrusting the inquiry to another person again? What you can do is you should say with this version we do not agree. Therefore, we want to disagree with this. What you want to say? Proposal notice has to be given to the employee. Then he will say why you have to accept it. Where is the he completely discharged in 2 reports. And where is that treatment by the learned single judge?
My lord, lordship may issue notice so that.
And the stay also. You can't proceed against an employer, rightly or wrongly. And how many days of absence?
It is more than a month.
At fully 13 days.
13 days.
3 days. Instead, you could have hanged him to the nearest tree in front of your society. Issue emergent notice. Learned counsel for the appellant employees, delinquent employee draws our attention to the inquiry report, which suggested dropping of the proceedings, especially when the allegation was not that serious. That is, absence from duty for 13 days. Person. Nothing has been reflected in the pleadings of the other side. Any counter was filed?
No.
No counter was filed.
Nothing was filed.
We are on being asked, we are told at the bar that no counter was filed by the respondent officials to the petitions. First of all, what action has been taken on the inquiry report before going for a fresh inquiry remains a riddle wrapped in enigma? First of all, inquiry after inquiry is nothing but torturing the delinquent employees, subject to all just exceptions, into which argued case of the other side does not fit. First, in the above circumstances, application having the application IN number.
IN number 6885 of
6885 of 2020.
No, sorry. IA is not there.
Yes, I did get
6694. 6694. Having been favored, the fresh disciplinary proceedings pursuant to order dated
my lord, that is 28/12/8/2014.
14. Fresh inquiry? No. Subsequent.
That is 31/7/2024. Order.
That is annexure 5, my lord, that is 28/8/2014.
28/8/2014 are kept in suspended animation until further orders. Okay.
Limitation is 12 days.
Huh?
12 days, my lord.
Delay we shall conduct. Standard pattern. Okay.
Item 17, Read Appeal 107 of 2025.
17, you lordship, a common order.
Not sure I hear this matter after a holiday because it's a matter relating to Gratuity.
Yes.
So the past.
And moreover, tomorrow the
left out. That has not been disturbed.
We'll call that matter. Call these matters of
Which order you want to?
along with
appeal pending is a common judgment.
other matters along with writ appeal number 70%. Give them. Yes. After vacation.
And date may fix it.
After vacation. Yeah.
Item 18, Read Appeal 249 of 2025.
It's a granting aid matter, financially. Maybe that doesn't see it tomorrow. Yes.
May I please? It's a case which is covered by your lordship's judgment dated 12/5. Your lordship,
It's a state appeal,
appeals.
and similar cases, my lord, such past order.
This has been
Only
left
the
out.
crux of the point is the Honorable Single Judge passed the order basing upon another case 8489 of 2023 mail. Therein, my lord, it has been specifically directed to the OUT authority to prepare a scheme, submit before the government. On approval, you may.
That was Justice Shashikant Mishra's order.
No,
earlier order.
It is Justice CP Satpathy.
No, earlier order, the Justice Shashikant Mishra, the first one.
And
That order was passed, similar order.
BP Satpathy, Justice BP.
At page 38, my lord.
this is the order. Your lords may kindly see.
Original.
The original order. Yes, that is
8489.
8 Two copies. A page खोला है. My lord, the very same judgment which was delivered by the Honorable Single Judge, that against that a writ appeal was filed, and that has been dealt with by your lordships and by dismissing the writ appeal. I have given the order.
Your Lords may kindly mark the name of the petitioner, Saubhagya Manjari Samantaray. And here the order Your Lordship have passed in WA 2315 of 2025, it appears at serial number 2. So the very same judgment passed by the Honorable Single Judge has been confirmed by declining interference by Your Lordships.
Which is that order?
This is the order I have given.
This one.
Yes, that order. Saubhagya Manjari Samantaray, Your Lordship kindly mark the petitioner therein.
8489 of 2020.
8489, and there against they have against that WA 2315 of 2024 was prepared 2315, which Your Lordship gets at serial number 2 of Your Lordship's judgment 2315 of 2024. WA serial number 2. Saubhagya Manjari Samantaray.
Para 3 my lord says para 3 my lord.
These are all cases of regularization.
Regularization.
Cases of regularization.
Listen, and Your Lordship, the Honorable Single Judge has direct.
Subject to.
See, 6/12/2023 is the order which you have challenged now.
Yes, my lord.
This refers to order in 8489 of 2023.
Dated 1910.
Correct.
Yes.
1910. That was put in challenge by you.
By yes, my lord. And this honorable court, this honorable court, no, my lord, para 3 for a amendment.
Para 3.
That is my lord's order, my lord. Exactly. My learned friend is also relying upon the same.
Our order.
Yes, ma'am. Batch of matters, sir.
In WA. This one.
The first one is 327. Second one is 231.
Yes, having heard the land council.
Exactly.
But so contractual it's not taking steps further the direction is given to university to submit the scheme for approval of the system by cross application. There is no state government system. No, what is your locus standi? University has been directed to regularize.
Yes.
How you are going to?
University has to submit a scheme before the government authority.
Correct.
They have to subsequently accept taking into consideration the.
Take a decision whether scheme should be accepted or not.
Yes.
Why you are? WPC 1491.
This is WPC OAC 1491.
There, OUT is not a party. That is relating to IGR. Your Lords may kindly mark the cause title.
The Inspector
General of
Registration Orissa, District Magistrate Koraput, and District Register Koraput, Secretary Finance.
They are your officers and you are entitled.
Yes.
How you are concerned with this judgment?
Yes.
Instead, you submit the report to the government. Government will take a decision, or it can put it in elsewhere, and it may say, no, we do not agree with the proposal of the government because that will be drilling a hole in the pocket of the government. We will not agree with that.
That has been taken care of in para 3 mills.
We have taken care of. Then nothing remains here. The state and its officials are in this intra-court appeal. First, they call in question the learned single judge's order dated 6/12/2023, whereby respondent employees WCC number 20707 of 2016 has been disposed of, conferring benefit on him in terms of a cognate case in WPC number 8489 of 2023 and a batch of other cases disposed of by the learned single judge by the judgment dated 19/10/2023.
Number 6-2.
No, 19/10.
That was 19.
That one.
1910-2020.
First time. Next paragraph. Learned counsel for the petition, respondent employee places at our hand our judgment dated 12/5/2026 entered in writ appeal number 327 of 2025 and a host of other matters that have been dismissed with the following observations at para 3 thereof. Okay, this I brought here. Whether university 3 and 4.
Yeah,
3 and 4 because
Please an observation.
scheme was already
Already
submitted to government.
Yes. So, my lord, here, my lord, OUAT has not come in.
Correct.
If the government
Government
will
has-
take the call subsequently,
That's the reason we.
anticipating something has filed this appeal.
Because the scheme is pending with them.
And that too, here the government is the Department of Agriculture. The other judgment he is relying upon, that is by Department of Revenue. Revenue and the officials there under.
Here
That was the
altogether
Inspector General of Registration.
Here Inspector General who comes under Revenue and DM Department. Here OUAT comes under Agriculture Department.
Yeah. Next. Learned counsel for the respondent brought our attention to the operative portion of our order, whereby appeal of the kind filed by the state has been negative, as mentioned above. The same reads as this. The 2 paragraphs are going to put this one is marked. Okay. Next. How many days delay?
338 days.
My lord,
In first case,
383, my lord.
Added to the above, there is a delay of how many cases there?
5 cases.
Delay of so many days. In the above circumstances.
That is a delay be condoned, my lord. Because in the earlier cases, my lord, prior to this, my lord, that was condoned, my lord.
Will condone delay. Every something.
Because my lord has observed that it is a policy matter of the state government. Financial implications are there.
There is a delay. There is an appeal filed of the booking in India. So,
But it is up to you.
Follows supported by a friend. Second, plausible explanation is offered. And therefore, application with allowed engagement.
Taking this pendency as the ground, the order is not being carried out.
Well,
They also directed some time because we are low paid employees, we are waiting.
No, for having to pay time for compliance is 3 months.
Probably.
Yes. This is lost. Due
The sub-item all are same.
all of us. We'll come back. We shall be coming. Mr. Mishra, we are coming back.
On behalf of Sogar Das, my lord, can you pass over this?
The Das was here sitting here?
Yes, my lord. He is legs, my lord.
After vacation.
No, my
Now
lord.
you want to argue?
Argue. Mr. Das, please.
Passover.
Passover.
Yes, my lord.
Item 20, WC 10636 of 2026.
May I please, Your Lordship?
Yes.
This is a matter where Your Lordship has disposed of the matter, giving the petitioner to breathing time to deposit the amount 15 days, within 15 days 30% and rest amount within 3 months, my lord. Your Lordship, the petitioner could not deposit the first 15% within 1 week. Thereafter, another cell notice has been made because the petitioner is suffering from cancer and the treatment was going on. That is not within my knowledge. So, my lord, if Your Lordship allowed to 2 weeks time, he will deposit 30% rest in 3 months or 4 months he will pay, my lord. He will arrange money from the relations, my lord. So huge amount he has expended.
But the date has been fixed to 26/5/2026. So before that, let him to submit any
He's suffering from cancer. Yes. It may happen to anybody. So give some time.
Yes, my lord. I don't have any option, my lord. But any.
You have made
only
application now?
things that before
My lord?
the auction date, my lord, let them submit some amount, my lord. So that,
30% by
the
that,
volatileness of the-
30% he will deposit by 26/5, my lord.
On 26/5, you will deposit on or before
1 or
26/5.
my lord.
Now you have made application for extension of the
Extension
period.
of time.
First installment also you have not paid.
No, when he failed within 7 days, again another cell notice they have published on CITTARANJAN. For that reason, actually I have no knowledge that he has given the prescriptions. I have not seen this. Actually, he is suffering from cancer for that.
This borrower's petition was disposed of by the order dated 9/4/2026. Wherein there are two reads added. Next. Now, an application in IA number 8958 of 2026 is moved seeking modification of the said order so far as timelines for payment of the prescribed installments is concerned. First, Learned Counsel for the borrower submits that his client is suffering from cancer, and therefore the court has to, the court and the bank have to be with lenient. First, Learned Panel Counsel for the bank opposed the application. Next paragraph. Having heard Learned Counsel for the parties and having considered all aspects of the matter in general and including the cancer, cancer which petitioner has been suffering from in particular, we having taken notice of the recent sale notice dated 16/4.
My lord, it is 15/5. 16/4/2026.
16/4/2026, we make the following, we dispose of this application with following the modification of the rate order. Number one, what should be done now?
30% your lordship had directed, it should be deposited as per my submission is within 26/5.
30% of the outstanding money shall be deposited on or before 31/5/2026. 31/2026. Then remaining amount, how you
In 4 months, your lord, 70%. Your lordship granted 3 months. Now already 1 month has gone. If the lordship granted 3 months, actually he has paid for 4 months. I have paid.
Another 35% of the outstanding amount shall be paid within a period of 2 months. Next, remainder 35% shall be paid within 2 months. Next following. First, next paragraph. Petitioner applicant is put to caution that no request for further extension shall be entered. Yes. Next, last. In the event this facility, which has been graciously granted by the court in special circumstances, not availed, it is open to the bank to take all coercive actions for recovery of the loan in accordance with law.
Till then, this cell fixed to 26.
It hardly needs to be stated that the auction notice dated 16/4/2026 shall not be given effect to.
Item 21, WC 17938 of 2021.
On behalf of Mr. Hon'Ble, sir, matter posted for final hearing can be taken after petitions.
Application 2021 matter. Admission also not happened. Any delay? Call after vacation, 1 week after vacation. At the request of his.
We are for the object.
Yes.
Item 22, WBC 40736 of 2021.
In person. Now, my lord, I took time to have a discussion with the officials. Little more time and already have a discussion about this person. Let me remember. Absent of more time is after vacation. Last week or any day.
No, what is the response of your official?
I think that senior officials who will be with me, he is not given. Some of other officers come. I told that you ask the senior official, then something can be.
We will fix a date.
Yes, yes.
Because already we have heard the matter.
Yes, yes, yes. That's it. I only to ventilate authorized.
If you are coming from Bhubaneswar.
Yes, ma'am.
Bhubaneswar.
My lord, they are always dealing the matter. But last
difficult.
my lord,
You have argued, na? We know that.
my lord, the second thing,
Call this matter on 24. How many matters are posted on 24?
7 matters.
7. Now put this also on 24. At 2 p.m. Yes. Come by 2 p.m.
Yes, ma'am.
Okay.
Item 23 has been adjourned. Item 24, WBC 6673 of 2025.
May I please not, sir? I am the opposite party. I am appearing on behalf of D. Roy, madam.
You are
He is
for
out of session, madam. Opposite party 5 to 7, madam.
You are for OPS.
My lord.
Where is your friend?
He is out of.
No, country. Your petitioner.
My lord,
Counsel for petition.
25, madam.
You are for petitioner.
24, madam. I am the petitioner, madam.
Union Bank of India.
No, madam. 6673 well 25. Double PC.
The state of Orissa, no? Yes.
That is elective matter, madam.
Election matter.
Elective matter, madam.
Electricity matter.
Electricity matter. We have filed order of ambushment, madam. The OP number of file the counter, madam. They have not given the counter copy of counter.
Which OP?
OP of the
Have you filed any counter for that?
My lord.
Just share a copy, one more copy.
My lord.
Right?
Madam, there is a problem, madam. Beg apology, madam. We have been remaining the darkness condition near about 8 years, madam. 8 years, 8 years, we have remaining darkness, madam.
Vigilance nahi.
No electricity line.
So we will have it on 25. How many matters are posted on 25?
3 matters.
3. Put this matter on 25. Yes, that's the request.
Item 25, WBC 18313 of 2025.
If I will review the counter, I'll tomorrow. After vacation.
I only got it to sir. The immediate question is that compulsory retirement, whether they will get entitled for the, if the compulsory retirement goes, whether he's entitled for this.
That is the only
Sanjay Sahu case I have cited.
Covered by Apex Court.
Yes.
To that extent, our order is modified by Apex Court. Na?
Confirm and only codified to the extent. Already automatically restored.
The compulsory retirement is set aside by extra tribunal.
By the tribunal, another 2 bench also granted the benefit. But this cutoff bench has not granted the benefit.
Okay. One week after vacation. Give that copy.
I'm giving the supplied copy.
I have that copy.
Okay.
Item 26, WBC 3034 of 2026.
May I please, my lords?
Yes.
The petitioner, my lord, is an auction purchaser, and by Annexure 1 at page 9 and 10.
Any urgency?
No, the urgency, my lord, on the last occasion, your lordships were of the opinion that notwithstanding the pendency of the case, because there is no stay for the DR80 at Kolkata, let the possession be given to me because they have filed a 14 application. The banks have filed a 14 application. The collector has allowed it. In 2025, the bank, as per my documents, they have deposited the requisite amount of fee, which is necessary, 1 lakhs amount, then the GST, whatever, that has already been paid. But still, my lord, the SP, my lord, is not granting the cooperation to the bank for possession. And I have been, my lord, being an auction purchaser since 2025, my lord, the sales certificate has been issued. Annex 1 is dated 37.
Who applies for the OPs?
But I am appearing for the bank, my lord. What my friend, my lord, senior is saying, my lord, that's true, my lord. In 2018, my lord, section 14 application was moved and the order was passed. And thereafter, 1 lakh, around more than 2 lakhs has been deposited. Thereafter, my lord, successive auctions paid. Thereafter, in 2024, the auction succeeded, and my lord, 2 of the flats have been sold to only one person. That is a company, my lord. For my lord,
1 crore, 1.5 crores.
No, my lord, we have been trying, my lord. What is there is a decree by the OA, my lord. There are decrees by the DRT which was not complied with, and 2018 decree, my lord. And my lord, in 2000, now we are in 2026. 2013 is the loan amount. Now, my lord, we have seen on the last occasion said that you will hand over the position subject to the result of the SME. That order can be passed because ultimately, my lord, he is pressing hard on us. My lord, we are not, and the entire amount has been deposited and sales certificate.
And for the OP number 6 and 7, we are finding the objection to them.
Hear that?
Yes.
We will look into the pass the order. Hear that?
And in the
anything to, you want to say anything? Interpretation and we have to pass over. Will he come back?
Yes.
Just pass over. We do not complain. Let us see. Pass over the request.
Item 27, WBC 8056 of 2026.
Yes, sir.
I am appealing for opposite party bank.
Let's say it is, I am mobilized to this honorable court that court has granted me some relief. And last 2 months I have, my property has been protected. As per the order of this honorable court, I have deposited the committed amount of 50 lakh rupees with the bank.
My lord, here what happened? After issuance of sales certificate, the petitioner approached this group. Sales certificate was issued on 9/3/2026.
To whom? Auction bill. What is the, have you made him a party?
Yes, Lordship.
You have made him a party?
To auction purchaser, I have not made any party.
No.
But bank is there. Bank has informed later on that they have.
I'm asking a question.
Lordship.
Have you made auction buyer a party to the proceeding?
No, Lordship.
Then you have to make a party.
Lordship.
My lord, here right now, if he'll pay the rest amount of rupees 56 lakh before the bank will release the property.
How? You have already given the property to the auction.
No, we have not handed over position.
Say auction happened.
Auction.
Sales certificate has been issued.
Sales certificate issued.
Then unilaterally can you do it to the auction place?
No, because of interim order, now the auction purchase is pressing hard, either to hand over the position or either to refund the auction amount. and as for the orders of this court, this petitioner has already deposited 50 lakhs.
And how much he has to deposit?
If he will deposit another 56 lakhs,
they will give back the property.
Will give back the property. Moreover, the auction purchaser has deposited 1,96,09,000 and he's demanding interest over that amount.
That also they have to make.
That's it. It is within 2 weeks. I definitely going to deposit 25 lakhs before
deposit the entire amount.
No, Lord. So that will be difficult for me to at a time depositing 56 lakhs. So at least 15 days, 2 weeks time may be allowed so that I can deposit 25 lakhs. And next within 4 weeks or 6 weeks, rest amount will be deposited.
So within 2 weeks, you pay
25 lakhs, Lord.
So 25 lakhs.
25 lakhs. So that
and the remaining amount within next 2 weeks. It's the interest which they have to make payment
They have
to the auction buyer.
Let me allow a little bit more time. So at least 4 weeks after giving this 2 weeks of time, so that I can provide rest of the amount.
25% you pay within 2 weeks.
Lots of
12.5% within 3 weeks. Remaining 12.5% plus interest within 3 weeks.
So my lord, auction purchaser is demanding 12% interest. So as per
you put that interest, he will pay that. Write down. You write down a memo. In terms of that, we'll pass under law.
So whether should I make this auction purchaser a party here or not? That is also because it has created that third party interest of created by the bank.
No.
That's why it is definitely.
He has sent a letter saying that give our money back. Therefore, in that case, you cannot buy more time. So prepare one memo. You give a memo. In terms of that, he says that you have to give money back to auction buyer. With, on how much it is? 12% comes to what?
I have to calculate.
You calculate that. Then
that's it. Why not? The banks would give a calculation that how much interest I have to pay to them.
What is calculable? What can be ascertained is certain. There is such a maxim. Bloom's legal maxims. It says what is ascertainable should be treated by the king as a certain. That way. You prepare memo. Come back. You got the point?
Yeah, got it.
25%.
Within 2 weeks.
Within 2 weeks.
Then after 12.5% after 3 weeks, then 12%, 12.5%.
The interest which they are paying, up to that, the interest will accrue.
Third party.
That's it.
Within 5 minutes, I will intimate.
Yeah. You get that.
Within 5 minutes, I will intimate.
That's one. So bring a memo. Yes.
Okay. I need pardon, man.
Yes.
I'm sorry, my lord, when the matter was called, I couldn't pay.
Which one?
Item 19, my lord.
19?
Yes, my lord. There is delay of 3 days, my lord. With a limited point, I have come up with a lawsuit, my lord. This is under the Payment of Gratuity Act, my lord.
Awesome. Who is your friend?
My friend is
I am for the opposite party number 1.
We'll do the conduct opposite party number 1.
1.
How many parties are there?
3 parties.
Yes.
Cooperative. I am appearing for only opposite party number 1.
Correct. How many?
My lord, here, my lord, three opposite parties.
2 are authority.
2 are the authority who passed the order.
Who is their lawyer?
Mr.
You only. No, party 1 now.
Therefore, the government can appear.
No, they cannot.
No, they cannot.
Because that's the authority who passed the order.
Payment of gratuity.
Yes, ma'am.
Act.
Yes, ma'am.
Who is the competent authority?
Central authority.
Controlling authority as well as the appellate authority, Labour Commission, ma'am.
Central Labour Commissioner.
Yes, ma'am. Labour Commissioner, Odisha.
No, that means Assistant Labour Commissioner.
Commissioner, yes, ma'am. That is.
That you have not made it.
Anyway, 2 authorities have passed the order, then I have made them part.
Those authorities have made party.
Yes, ma'am. And my lord, final order passed by honorable single judge. I have a limited point, my lord. Everywhere I have succeeded. The only observation made by this honorable court, the after conviction in the vigilance case, then the money which I have taken, I have to refund the same. But as per the section 46 of Payment of Gratuity Act, that is
not to be refunded.
Not to be refunded. 13 is immune for me. Section 13 is very clear.
Because your contribution is also.
Yes, ma'am. And even that can be attached in civil court decrees also.
No, it is immune from
yes, ma'am. That is the only guide for me. And that idea which is given by the honorable single judge, that is against me. That part I am challenging you.
What learned single judge says?
Last paragraph. May kindly have a glance to page 68. I'm 69 reading, my lord. I'm just reading small paragraph, my lord. So while not interfering with the order at annexes 7 and 9, this court direct opposite party number 2 to release the balance 50% gratuity amount in favor of opposite party number 1 within a period of 4 weeks. Hence, however, such release of the entire gratuity amount will be subject to final outcome of vigilance proceedings. That is the only thing I have challenged you.
Which is that section? Kindly read.
Section 13.
13. How various high courts in the country have interpreted.
Well, one judgment against me, all the judges in my favor. In that judgment, specifically Mahanadi Coalfields Limited case, there what has happened, there was a clause that they can proceed or initiate the proceeding after retirement. In that is the only circumstances where the money recovery was made after retirement event. Here I have a retirement. And here section 4.6 is language is very clear. That is the only thing which is against me. That speaks that under which circumstances the gratuity should not be paid. That is the moral turpitude. If I have damaged something, public property, in those circumstances, gratuity cannot be paid. Otherwise,
the vigilance case is not a case involving moral turpitude. It is.
No, well, had it been so, I could not have argued. On that count, I have number of judgments, my lord.
Kindly read section first. Let us see.
I'm sorry, my lord, I missed the. Give this code, that code, I missed the gratuity act.
Payment of gratuity. Give that gratuity act.
Where? It's छोटो पट्टी वाली से. I have been talking about it. Thank you. My lord, may I read, my lord? This is section 4.6. First I am reading, my lord. 4.6. Section 4 in subsection 6, my lord. Here it speaks, my lord. Whoever contravenes the provisions of subsection 5 shall be punishable with fine which may extend to 10,000 rupees, and in case a continuing offence with further fine which may extend to 1,000 rupees for each day during which the offence continues. Then, my lord, I'm sorry, I'm wrong.
Take that book, that becomes easy.
Yes, my lord.
I also feel very comfortable with the books.
Yes, my lord, I'm sorry. I'm extremely sorry, my lord. So, passage 4.6.
Which is moral turpitude.
Yes.
There is one judgment of the apex court which said, if an offence attracts fine of 2,000 rupees and more, that should be treated as an offence involving moral turpitude.
That is to be interpreted. It is, my lord, what my lord is saying, that cannot be denied. But I was trying to find out judgments against me. Because this is a particular circumstances where it speaks the only the thing, the moral turpitude which will come out, then I don't have any case at all.
You're right.
Because that is also provision available in the Corporate Societies Act itself. They can recover the money by creating dispute case, then 103 is there to execute and recover the money.
No, question is not that.
Well,
how section is structured?
Yes, well, now I'm reading.
There is one judgment of the apex court.
Yes.
Go to the apex Honorable Supreme Court on the idea of moral turpitude. There is one such judgment. I don't remember the name of the judges, which said any offence which attracts a fine of rupees 2,000 and above is an offence involving moral turpitude, because that question arose under the provisions of Representation of People Act, where a provision said if a candidate is convicted for an offence involving moral turpitude, he forfeits his seat. That was being interpreted by the apex court. I do not, maybe Justice K.T. Thomas or judges of that stage. Go to that.
Here, my lord, vigilance case, that is something I will examine.
Vigilance case is always treated as an offence involving moral. That is the reason why Justice Malimat Committee, the V.S. Malimat Committee suggested in offences involving the vigilance case, etc., there shall be no plea bargaining. And that has been enacted in the amendment to 1973 Act. Now, erstwhile, the CRPC 1973 provides for plea bargaining, as in English law, American law, Australian law. But there is a provision, chapter, which excludes certain offences from that chapter, saying that there shall be no plea bargaining. Therefore, Justice Malimat Committee was a great judge. Malimat Committee has considered this aspect of the matter. Apex Court considered Justice Malimat's report. You just look into that and come back. Your preparation is not sufficient for us. You have to come with Chapan hope.
One more judgment of this court is also there.
It
is Justice L. Mahapatra.
Yes, ma'am. Yes, ma'am. Definitely. My lord, what I pray, my lord, if you also will place this matter after baptism, phrase, my lord, order that.
You're a foreign advocate or advocate from local bar?
No, I'm from the bar.
Then we'll have it 1 week after vacation.
My lord, may I pray, my lord, that may kindly fix, because my lord may hear this matter.
That may not be correct. All are appointed.
No, my lord, because my lord has appreciated the point. That is what my anxiety.
Yeah, in fact, this point will be appreciated by brother and sister judges within 30 seconds. I have taken more time.
30 seconds, 27, 24th. 24th, my lord, date may kindly please.
24th, we have already posted 6 matters.
My lord, this may be added.
See, 23rd.
Oblige, man.
7 matters.
7 matters. 25.
4 matters.
4 matters. They put that.
High low, please. High. And delay has been condoned now.
But without notice to brother, the other notice has to go. Issue emergent notice.
No, they have already entered the appearance.
Other two, whether
advocates or
my lord, one judgment I was going through, the 3 days delay can be condoned subject to variance. Other side will come and raise the objection, it should not be condoned, that points are different. But I just want judgment, I was going through that, I found that delay can be condoned, but this has got ample power to condemn this.
Correct. But exercising condition is other should be.
Yes, my lord, I am not.
That's a funda, there's state authority.
My lord, Mr. Mohanty will be appearing in that
In those matters,
item 19.
Mr. Mohanty, learned panel counsel he will be.
No.
EG. Mr. Mohanty, Mr. EG requested to accept notice for OP numbers 2 and 3.
I will inform him regarding 19, item 19.
Next paragraph. There is a short delay of 3 days.
Yes, my lord.
In filing the petition. Application in IR number so and so supported by affidavit seeking its condonation. First, delay being too short to be legal, and there being a plausible explanation therefore, is condoned. Application is allowed. Published.
Item 28, WBC 10480/2026.
I'm challenging an order of the Central Administrative Tribunal. The tribunal has held that in the absence of rules, re-evaluation of answer scripts is not permissible, and 2 judgments of the Supreme Court have been cited. My submission to your lordships is that the ratio is incomplete. Because those same judgments also.
In another paragraph,
yes, ma'am.
They say between.
And if there is a discrepancy in the answer key, then re-evaluation of answer scripts of all the candidates is permissible, which is what has happened in the present case. Because my learned senior has filed an IA, there is a procedural defect in the writ petition. I had not annexed one of the counter affidavits filed by the railway authorities.
You repair that.
Yes, I'll repair that. I'll file an action.
May I pray, my lord? The matter may come under orders and after vacation.
Matter can be finally heard with short question of law.
No, repair the pleadings.
Yes.
Petition to be repaired within 10 days. First, if repaired, call a week after vacation. Okay.
There's an
Both the
Interim order to continue.
both the item 28 and 29
Together.
Oblige.
Item 30, WBC 111400/2026.
In item number 30, they've already taken possession of physical possession of my property. And I filed an IA for release of some articles which are there in the house, with the bank authorities. They filed a reply bank.
Everyone files the objection to the IA.
Right. Whether there are they are saying some certificate yesterday your friend.
No, they've admitted that they will release because their objection first page, the very first page also paragraph 5.
Mr. Utham.
For the auction purchaser.
And he has no role. He has no role.
Sir, the
Possession is given to you. Then you have to say something. Because you are in the possession of the property. Allow them to take the goods.
They get admitted. Paragraph 5, the same application they stated.
What you want to take?
There's only a few items. Wooden almirah containing clothes, Rolex watch,
milords, T-shirt watches, some jewelries are there, milords. And milords, one electric chimney kitchen with milords, burning burner, milords, and air conditioners. All these they have stated in their reply that they paragraph 5, the OP state that the items stated in IA in schedules are there.
We have not taken the possession of those items. So things which have been given there, we have only mentioned that we have never taken possession of the assets.
Mr. Ratho, now you can't put the problem to him also by admitting that these things are there. He will have a say in the matter. Now, whether when taking possession in your state, whether everything is videographed? Inventory is taken? Only inventory or only videograph?
They say that they have prepared a Panchnama.
Only in the inventory, no videography.
I'll file the Panchanama and I'll also inquire if videography has been taken. So this I cannot
in their presence, I will take this. You will also say in their presence, I will take the article.
Bank is not admitting that these items are seized. Bank is not admitting. While Mr. Samantha says that these are the items which are taken away by the.
They were there in the house.
Let me take. In fact, I have taken over possession. They have delivered me the possession of the property.
Yeah.
Whether these properties are there or not.
You send your client.
Yes.
When petitioner's advocate, the bank advocate also will come there.
Yes.
We can put an end to this.
Yes.
For the sunset of the day.
Of course.
Yeah. Send no.
Yes.
The short grievance of the petitioner borrower.
Yes,
borrower is that the movables and articles kept in an almirah or the like in the security property remain in the property as a possession of the property having been taken over on
16/5/2026.
15/5/23 and handed over to the auction buyer on
same day. 16/5.
Handed over also same day.
No, that is on 16/5.
On the very day. When you took the possession.
Same day. 15 we have taken possession.
Or
16 we have taken.
Handed to possession handed to auction buyer. First off. What has been mortgaged is the immovable property. And therefore, in respect of apparent movables, mortgage does not affect.
Whether they are there.
Therefore, the bank has filed objection
There are 5 mentions.
within para
5 says the OP state that the item stated in the IA in schedule was never seized by the OP number 1.
No, seizing is different.
They have used the wrong word. Whether they have been taken over possession or not.
First, there is some dispute as to whether these articles are there or not. However, we presume that they are there. Which presumption other side can rebut? First, be all this as it may. Now, both the sides shall go to the security property and ascertain the availability of the movable property and articles. With the videography.
Yes.
First of all, call this matter.
No, date has been fixed also.
At 3 p.m. today. Yes. 3 p.m.
Some more. Along with both the sides, let a public officer be there so that it will be more
jurisdictional inspector of police is directed to depute 2 police constables at the site of this order to accomplish the task. Non-compliance of this order by the police will be viewed very seriously, and adverse entries may be made in their service register. Next, a copy of this order be shared with the learned advocates appearing for the parties on record, and with Mr. Behura. You advise with Mr. Behura, learned AGA, Mr. Behura, to communicate the same to the jurisdictional police. First.
And some police officer be there instead of constable.
Police officer only, but we do not know what all is happening.
Local Tasindar or the
No.
Then you are for executive magistrate you want. Any executive magistrate to be there.
No, for this, police constables. The order is in such a language, they know what we will do if they do not comply with our order. All right, go right now. And till all they go, nothing should be removed. The person in possession of the property is hereby warned not to remove any of the articles from the security property in question till the exercise as mentioned above is accomplished.
Yes.
Post a police immediately before right in to accomplish, to ensure this does not happen. Contrary would not happen. The police inspector is directed to put 2 police constables right in front of one in front of the house and another in the back door, who shall ensure that no articles are removed. Okay.
My lord, sir.
Bank officer is also.
Bank, that's better. That's better. I'll put to bank officer also. Okay.
That's immediately. Today. Immediately.
I mean, give that order. Now,
My lord, sir, details.
To post 2 police officers.
Details is not with.
Right now, it is prepared.
Yes. नहीं वो जगह का नाम क्या?
Subject property property and other things details they have to give na. And send your client there immediately. Yes. Next. It will be at 3 p.m. Yes, at 3 p.m.
Item 31, WBC 15774 of 2026.
Yesterday, I've served on the bank.
Yeah.
This is the case where I have taken a loan from opposite party number 3. I am regular in repayment of the loan. Now the opposite party number 1 bank claims to have a mortgage over the property. They are seeking to enforce the security in respect of my property.
They are entitled.
Sorry, what?
They are in law entitled.
No, they are not.
Why?
Why, my lords? Because I have approached the DRT in an application under Section 17 saying that all the title documents in respect of the security are with the bank from whom I have availed the loan. My bank has already filed its reply stating whatever that the documents are in fact with them.
Read one paragraph from Mullah's transfer of property.
We'll come to that. We can come to that later on, but you kindly have the facts first. As far as the opposite party number 1 bank is concerned, from 2023, we are now in 2026, they have not filed their reply. They have not traversed any of the assertions that I have made that the mortgage is in fact with them, the documents, security documents are in their custody. It is just they are saying in a newspaper advertisement that I have secure mortgage in respect of this property.
Who appears for that bank?
Mr. Sahu appears for that bank.
I am for the other bank.
But legal position is against you.
Well, it's legal.
But subject, kindly listen to us. You have to have patience.
So, yes,
Otherwise,
sir.
call this matter after vacation.
Well, Your Lordship, I just
Others
wanted,
will follow you.
well, I am just placing, I wanted Your
What is
Lordship to
this?
have the
No,
facts.
Mr. Mukherjee. You should learn to be patient with the judges.
No, I am sorry, my Lord, Your Lordship.
You are a senior advocate. We are telling you.
Your Lordship, ma'am. Your Lordship.
Others start following you. If senior advocates start doing like this, as the fresher, what should the youngsters sitting in the court learn?
I'm sorry for that. Sorry,
Yes.
Your Lordship.
Yes, brother, where is the, who appears for,
Yes, madam. I am appearing for the Indian bank, opposite to party number 1. In this matter, the essay is pending for the PHC member. And but now we have the first charge holder.
where is that?
Just now we have received all the documents from the bank just now.
But the TRT is pending for last 3 years.
That's all right.
They are not filing.
Whether he is saying, show me the mortgage.
But that is precisely the.
Have you taken up the stand before the DRT?
They have not filed a reply. 3 years. 3 years.
Show from your reply that you have taken a stand that it is.
That's asking before you, but just now the bank officials has given the documents. So,
Any urgent interim?
Well, I am being harassed from time to time. People are coming saying that we have purchased the property. Please vacate it. My 75-year-old, the petition number 2, 76-year-old, she is staying there alone.
What is the interim order you have sought?
I have sought that let there be a stay of my, there be a status quo with respect to my possession, Manoj.
After all, you are not in possession of the property. You may be having the charge. Is it your case that you are in possession of the property?
And because we are the first charge.
Show that. Well, charge is one thing. Is it a usufructuary mortgage?
Yes,
Only in usufructuary mortgage or mortgage by conditional sale or English mortgage, the possession of the property will be with the mortgagee.
My lord, in this matter, the bank officers tell you that your enforcement of directory has already, this is a fraud mortgage in the sense. So my lord.
That will decide, but he is in settled possession. Don't disturb him till the next date of hearing.
Two banks are fighting for one property. So that's the issue. Two banks are fighting for the one property. That is the core issue in this case.
No, what we have been taught in the law college is mortgage is transfer of interest in an immovable property for securing the repayment of a debt or discharge of an obligation. Number. After the mortgager does not cease to be the owner of the property. Any person who buys the mortgaged property buys the equity of redemption. I'm just reproducing Justice Mukherjee's, not this Mukherjee, Justice S.P. Mukherjee of Calcutta High Court, whom Mullah quotes one paragraph. So if a mortgaged property is bought by XYZ, what he buys is only equity of redemption. But if he is already in possession, you are not supposed to interfere with that possession till next date of hearing.
I agree.
Heard that senior advocate, Mr. Mukherjee, first time, he submits that his client has bought the subject property and presently he is in possession of the same. First, he further submits that officials and others claiming to be under OP number
1.
OP number 1 or unnecessarily visiting and hovering, visiting the property and hovering in the vicinity. And therefore, there is apprehension that possession of those clients may be interfered unlawfully. Next one. Learned panel counsel appearing for the OP1 bank claims that his client holds a prior mortgage and therefore the question raised in the petition cannot be traversed by the right court. First of all, when asked as to which document he is holding to prima facie show the argued prior mortgage, he has not shown any, but says that the same would be produced in due course. First one. Next paragraph. In the above circumstances, the application in IN number so and so is favored, and the OP number 1 is restrained from interfering with possession of petitioner's possession of the property without leave of this court. All right.
I am appearing for OP3.
You appear for OP3. Yes. Do you support his case? Or?
No, I support his case. I filed the reply in DRT claiming I have the prior mortgage.
That
will decide, my lord.
There is one bank which both banks claim prior mortgage.
Same property.
Same property. Both banks claim the loanee is in jail because UOW has instituted a proceeding and I am being sandwiched, my lords, in the meantime.
Well, anyway, we have protected your
claim. This may kindly be issued to opposite party number 2, my lord.
No, issue more than what issues.
My lord, urgent certificate code. Urgent certificate code.
Yes. Yes.
Item number 32 has been adjourned. Item 33, Read Appeal 3103 of 2024.
I'm from the respondent.
Yes, sir.
Mr. Kunti had taken the adjournment last only for 1 day because he said that there has been the poor person is suffering since 1996. Despite the poor man is suffering since 1996. Despite having 96.
Then he is fully accustomed to all suffering. So that immediately after, post immediately after the
Lordship fixed date.
22nd home. Put it as 5. Yes.
Item 34, Read Appeal 3276 of 2024.
There are 3 appeals before your lordship, one of which is state appeal also. My lord, the guidelines of the UGC will prevail or the state guidelines will prevail, that is the dispute.
Covered by Justice Altamash Kabir's judgment.
I will come with all the judgments, and some judgments are also in favor of the state in the federal structure, and the core guideline, if it is not violated, ancillary guidelines can be framed by the state. That issue is to be decided any day after vacation. Your lordship may fix it any day after vacation.
Mr. Kari is appearing.
I am appearing for the respondent in the first case.
I am appearing the respondent in second case.
Immediately after vacation. 1 week after the vacation.
1 week after.
At the request of the DGA.
1 week of filing.
But matter is covered.
Yes, I will come.
Covered.
Yes, date may be fixed.
Finally, final disposal lordship may also say.
Certainly.
30th.
May I pray for item 26, which was passed over? Because there may be a remote chance of your lordships assembling after lunch.
30?
No, 26.
26, yes. WPC 3034.
Your lordships are...
Yes, sir.
Lord, 30th of June, my lord.
Yes, 30th of this.
This particular matter, my lords, my learned friend has filed a
Item 26.
26, my lord.
26, that subject to outcome of ARTF.
My lords.
Well, let it come after vacation. But anyways,
That paid
for the
I am appearing for the petitioner.
that auction buyer.
Option by 1.5 crores.
You are
paid.
for the bank. Where is your friend?
My friend was here only.
Yeah.
So can I pray, my lord? I'll take my chance after lunch.
No, today not possible. You know that we are in a function today. Yes. Vacation. 29. 29. After vacation.
Item 27. My friend has submitted that one regarding
Give that.
And where is he now? My friend has stated about payment of rupees 50 lakhs, not rest of the dues. Rest of the dues of the bank is 56 lakh. And auction purchase will take 6% interest. He has not whispered anything for it.
Let me
before the TRT, and therefore we decline indulgence in the matter. So we had granted some relief to him in terms of our interim order. Reputation dismissed.
Lordship, let me explain,
We have
Lordship.
said that.
Yes, Lordship, as per your order only, I have prepared that.
Well,
But
6% you have said. The letter is for 12%.
no, Lordship, he is saying 6%. I am not saying anything,
Where
Lordship.
you have said?
I have given the proposal which I have given that 3 weeks time that I have taken as per the instruction of this honorable court. First 25 lakhs, then 12.5 lakhs, then 12.5 lakhs.
He is ready to deposit 50 lakhs, but not 56 lakh, which is bank dues.
Lordship, I have my prayer to this honorable court is that they have given me this sale certificate just now, and that is the sale certificate is saying that 9/3/2026 they have issued the sale certificate, and the notice demand of position that they have given, that is also 9/3/2026. That is
mentioned.
running page number 13, Lordship.
It's all a question of calculation, which we will not do.
Lordship.
You go before the DRT.
They have filed one essay. The essay number 30.
Yes.
Direct the essay to be disposed of at the earliest.
So, Lordship, then the finally is
With our version. Yeah. Give it back. You have not mentioned anything about the interest payable.
No, that is, we are ready to pay all the.
Why you have not mentioned? You are just going on arguing like this and wasting time of the court.
Pardon, Lordship, I am since applies this code that I am not wasting the time, but the confusion that
Afterwards, you prepare fully and don't waste time of the court.
Lordship.
Represents the payment of gratuity.
My lord, sir, this is intercept between the employer.
No, that's not it. But you represent this.
My lord.
First respondent, payment of gratuity authority. Controlling authority under the payment of gratuity.
Yes, ma'am.
And second respondent has entered, the second respondent, who is the answering party, has entered appearance through his counsel, his or her, his counsel. First sentence. Next paragraph. Both learned advocate appearing for the appellant institution and learned advocate appearing for the respondent employee have settled the dispute between them and a joint memo of settlement, like this we should write, joint memo of settlement dated is filed reporting settlement. First of the said memo reads as under. Next paragraph. A perusal of the joint memo of settlement convinces the court that there is no fraud or fabrication or the like, and that the settlement is in the best interest of the parties. First of all, there is no legal or factual impediment for disposing of this appeal in terms of settlement, making it a rule of the court so that if its terms are not complied with, contempt petition can be moved. First, yes, with the above observations, the appeal is disposed of, modifying the order of the impugned order of the learned single judge. First of all, when a balance amount correspond within a period of 1 month. No? Next paragraph. It is made clear that in terms of the subject settlement, if the amount is not paid within the period of 1 month, the same shall carry interest at the rate of 1% per month. First of all, this condition is added by this court. No comments.
That's been item number 27.
Over item 12.
So that in the interest part also, my client has agreed to pay it.
I was seeing that. Is it all right now?
But he's paying for 2 months. So my request is that may be reduced to 1.5 months or 1 month.
Some justice has to be. You want money and you have nothing to lose because interest you will earn.
That is okay. That's okay.
Yeah. The list in this petition essentially relates to coercive recovery of loan proceedings constituted under the provisions of Surface Act 2002. First one. After service of notice, the OP Bank has entered appearance through its panel counsel. First one. Our order was on 15.3. Next paragraph. 15.3 order. On 15.3, go to 15.3.
No, 15.3 order.
Our order.
Yes, just leave it.
On 17.3. On 17.3.2026, we had made the following order. Paragraph. Following order. Next. Next point. We'll say both the sides have settled the issue.
That's it.
But have you put your signature to this?
No.
How to do it? Yeah, you put signature. Afterwards, you can put at the instance of, on the request of this court, both the sides have settled the list, and accordingly A memo dated 20 May 2026 reporting settlement has been filed. First one, the same reads as under. Next paragraph. Learned panel counsel appearing for the OP Bank, although initially opposed the petition with vehemence, now agrees with the proposal of this court to accept the memo of settlement so that bank would get the money without any coercive proceedings, and for the delayed payment, it will earn interest also. First one. In our considered view, the settlement is in the best interest of both the sides, and neither law nor facts of the case as pleaded before us come in the way of disposing of this writ petition in terms of above settlement. First one. Ordered accordingly, and writ petition is disposed of.
Let's say.
Last you right.
Let's
In the event the borrower fails to keep his borrowers fail to keep their words as recorded in the memo comma, it is open to the bank to take up all coercive actions against the borrowers or the security property or borrowed the security property in accordance with law.
Let's say small prayer to this honorable court is, after giving all that my money, so its order should be given to bank that they can return my original documents. That also.
It hardly needs to be mentioned that after repayment of the amount as has been specified in the memo, including the interest at the rate of 12% payable to the auction buyer in terms of his letter dated. Give that letter dated date. You mentioned that date you have given, na? Yes, great for report.
Only orally bank submitted that he is demanding 12% interest over the depository amount.
Whatever it is. Is remitted to the bank, and the existing loan is discharged, comma, the bank shall return all the title deeds to the concerned persons. Because others may give sale deed for securing your loan. We don't know. We are given. They cannot be given to you. If whatever sale deeds.
Whatever documents, secure documents are with the bank will return.
Given. Along with a certificate of discharge of loan.
And one request is the mode of payment may be recorded. Which has been mentioned in the memo, that may be recorded in the order sheet.
Well, the memo itself we are reproducing. The whole memo itself we are reproducing.
This is part of it.
Yes, it is part of the record. Okay. Next.
So item 12, WBC 16025 of 2026.
Yes, sir.
Lordship wanted to know what is the amount due. 30 lakhs, it is said that out of three properties, not two properties have been already sold. But so towards the amount 30 lakhs is due and interest. So I've only made an application for OTS now for offering 30 lakh. Let them consider that, take a decision independently.
Who pays for the bank?
My friend.
Your friend is not here. Maybe after enjoying sumptuous food, he has gone home. But we have no option.
Day after
we have to come and sit here.
Day after tomorrow, I will intimate my friend so that.
Yeah. Yes.
But that I may be allowed to. But item 30.
Item 30.
Pursuant to my lord's order.
Correct.
Parties are there on the spot. They are geographing. and the whole thing is videographed. They are doing it.
Police also are there.
Police also is
Oh,
there.
my lords,
Police is also there.
they are there. Okay.
They are complying with your lordship order.
But you should tell police not to harass owners and inmates of police, not for that purpose.
One officer is deputed.
My client even has not entered into that property. The bank had put a seal over the door and that is still there. So we have not even broken this seal
at all.
So that's still there. My client. So today it will take some more time.
We'll have it tomorrow.
Tomorrow, yes,
tomorrow.
Let tomorrow. It will come out.
Yes, yes. Instead of 3 o'clock, lordship may say tomorrow it will do it.
One sentence you have to add to that order. The submission of learned senior advocate Mr. Arfo appearing for the auction buyer of the security property, that the actual possession of the property is not with his client.
They have handed over.
Though actual possession of the property is with his client, Gama,
We have not yet opened the seal.
the same has not been occupied by opening the seal put by the bank.
The bank.
Put by the bank. Okay, we'll add that one.
Yes, sir.
Otherwise, tomorrow buyer should
Yes,
not
yes.
face problem. Okay.
Tomorrow we are coming back.
Yes, please. Mr. Ratho, you advise your client also.
I have already told him.
What?
Whatever is there, it should be given back.
Yes, that's what.
Item 35, read appeal 519 of
This matter
2025.
lawsuits wanted my friend to take instruction that 75% disability autistic child may also. So
They are saying that we are submitting the application for PRS. But they didn't receive, the department not received the same.
No.
Neither he has submitted application nor he joined the place of posting. So what I am suggesting, my lord, what I am suggesting, let the join the posting place. Immediately they should submit this PRS application. We'll assure that he will be processed immediately and he will be released.
one day they will not insist me upon me joining and do perform my duty there. I will only join for a day, submit my VRS application.
You join and if you
You have to
submit
report for
application
duty there. For VRS, you have to comply with the order.
Right.
I will. You should report for duty to the
And
client.
submit my application ready that day.
That is helpful because non-joining of they have started the proceeding.
Obviously.
If they join, that will be sorted out.
That will
And
be-
if you submit the application, then that can be considered by the authority for living.
No, very fair, no. My friend is very great. It will save me also, no.
So with that observation, can we dispose of, or you should call this matter some other day? We'll make some observation.
Yes.
So that later you are playing
Take
project.
observation.
Otherwise, tomorrow if they take action,
Yes.
again you have to come before.
Right,
the
no.
court.
Yes. So LC may keep it, having observation, basing on that, I will advise them to do it correct.
Yes. The essential grievance of the petitioner is against the essential grievance of the appellant.
No.
Appellant.
Appellant.
Appellant employee is against the transfer order dated 29/5/2018. What is that another order 14 for 2017? 27? That date has yet not come at all.
27.
In the prayer.
Then it's no. Oh, no, 2017. No, that was initial.
No, it cannot be 17 also. Oh, and 29/5/2018 and 14/4/2017.
That's in the prayer page 37.
Please to follow the
That will be tried.
the essential grievance of the appellant that was ventilated before the learned single judge was against the transfer order and consequent movement order.
That is 17 minutes.
Which eventually resulted into relieving order dated 10/9/2024. First term. For certain regions, the appellant wants to remain at Bhubaneswar and in support of his claim for retention, he has pressed into service 2 office memoranda dated 5/1/1993 and 6/6/2014. First off. Next paragraph. Both the sides made vehement submission on merits of the matter. First off. However, very graciously, they agreed with the proposal of this court that in terms of the transfer order, the appellant should be permitted to report for duty at
Jammu Mills, by Annex 2018 order, Jammu, Bihar.
215 battalion. 215 Bihar.
No. Actually, 215 battalion, Jammu, Bihar Mills.
Write down and
I will give you.
Page 111, let's suppose.
It there means the brief.
Moment order.
Bihar.
Page 111.
Is 111 mentioned? No?
Yes, Mills. Annex 10 of the repeats on page 111. Group Center, CRPF, Bhubaneswar to 2015 battalion.
Page 111, link 10. Item number 2. Item number 2, na?
Yes, ma'am.
CRPF, BBSR
to 2015 battalion.
Serial number 5, let's say. Serial
number 5.
Yes.
The party in charge of the arrival of the
report to the commandant to item number 5 in that. So and so. And his application for VRS to be made within 2 weeks shall be favorably processed by the officer. Respondent by the respondents within an outer limit of 6 weeks.
Yes.
6 weeks. First off, we place on record our view that during the absent period, the appellant shall not be entitled to any benefits, service, monetary or otherwise.
So they should make it leave, otherwise pension will be getting a problem. They have to sanction a leave. He will not get it benefits, but leave will be adjusted. What on leave he has.
However, leave in credit shall be adjusted to the absent period, to the period of absence. Leave in credit, if any, shall be adjusted to the period of absence. First off, the appellant shall report for duty at the transferred place as mentioned above within 1 week. Within 10 days.
Yes,
within 10 days. Record from this day. Any disciplinary proceedings are taken?
Yes, they have issued a notice, but disciplinary proceeding has already been initiated against me.
In view of this settlement, there shall be contemplated disciplinary proceedings shall be dropped.
In respect to this issue.
In respect of the
absence of duty.
Delinquency of unauthorized absence.
Yes.
First, ordered accordingly and writ appeal is disposed of. All right? Yes.
Item 36, writ appeal 789 of 2025.
Any urgency, brother? We can have it in the first week of July.
With a small prayer. It's date, it's immediately after. It's no confidence motion covered by your lordship's judgment.
It's covered by judgment.
Yes, 24, madam.
My lords request hearing, full
But
pleasure.
hearing. All right. First week of July, which date is coming?
So first July.
1st July. All right. 1st July.
Both the matter.
All right. Both the matter.
Item 40, Rate Appeal 2035 of 2025.
14 is after vacation. For me, antedating of regularization. My lords, this is prayer for antedating the regularization. Because of some application of reservation quota, it was not given. It requires hearing, my lords.
No single direction for notional benefit. The person who are junior to me, they have elevated and promoted prior to the petitioner, and the honorable single is only directed without disturbing their promotion, with notional promotion from the date of they have got the first benefit.
1st of July. Finally, at the request of AG. Covered by judgment?
No, covered by
Not covered.
but no financial benefit has been granted by the honorable single judge.
That day we do that. Okay. Next.
Mr. Service.
Forward.